everyone. I'd like to welcome you to Trademark Abilities Insider. My name is Stacey Calamares, and I'm a trademark attorney and the lead instructor at Trademark Abilities. Trademark Abilities is a comprehensive online training academy for lawyers interested in learning the practical aspects of practicing trademark law at the USPTO and becoming confident trademark practitioners. Through our signature masterclass, we provide the practical and strategic learning necessary to set up a trademark practice so that lawyers can confidently and effectively represent clients before the USPTO. Our templates and other resources have been described by our attorneys as a trademark practice in a box. I want to welcome you, Katia, to Trademark Abilities Insider. Through this series, it is my intention to interview people like you who have insider knowledge that helps make the life of a trademark practitioner a little bit easier. And with that, I'd like to turn it over to you, please, to tell us a little bit about yourself.
Thank you, Stacey. First of all, thank you for having me. I'm really excited. My name is Katia De Clercq. I am a Benelux and EU trademark attorney, and I work for Gevers. I have for a decade now. Gevers is an IP service firm situated in the heart of Europe. We've been existing for over 120 years, so that's quite a long time. And we are a one-stop shop, or our firm is a one-stop shop. So we try to advise our clients from the very beginning of their project, and we help them strategize, obtain, and protect their IP, even enforce them, and even monetize them. I am advising clients, multinational clients, particularly a large part US clients, but also Europe-based bigger clients and small companies, SMEs, on various projects, mainly trademarks, but also design rights, copyrights. And given that I have a background as an attorney at law, I'm also heading our dispute resolution service, which is the service which helps the clients who have enforcement issues. So when they come across an infringement on the market, or when they are being threatened to be sued for committing an infringement themselves. I really love the combination. So at one part, there's the legal work, but on the other hand, there is also the commercial work. So it's really building the relationships, the long-term relationships with clients, and getting to know them, getting to know their business, getting to know their ambitions, which motivates me to do my very best. And finally, I'm also part of the international team, because not only our European-based clients are very important to us, but also our US clients, because in general, they have really interesting projects. They also have really nice trademarks and brands to work for, but they are really nice people to work with, very outgoing, and in general, US clients kind of have the go-get mentality, which I really like. So they're very straightforward. So it's quite a lot on my plate, but it's really exciting to do this on a daily basis.
Yeah, that's great. And we're so delighted to have you here. I obviously am very familiar with your firm. I've worked with your firm during my days in big law, and think very, very highly of your firm. So I'm just thrilled that you could join us today.
Thank you. Thank you. It's really nice to hear.
Can you help explain for our audience the protection that an EU trademark provides? Just the basics, right? So when a trademark owner is interested in securing protection in Europe, we often recommend an EU trademark, and help us understand why that might be a good thing.
So first of all, an EU trademark provides a unitary trademark protection throughout the entire EU, which consists of 20 EU member states. As of the 1st of January, the UK is no longer part of the EU. But nonetheless, at a reasonably low cost, you can obtain a very wide scope of protection. And with a reasonably low cost, I mean that you can already start applying an EU trademark for under €1,000 for the first class. Also, You can obtain protection, as said, in a large part of continental Europe, with a market of 500 million people who import over 2 trillion worth of goods each year. That's quite a large market to target. Also, since you only have to apply via the EU office, you have a low administrative burden to obtain a protection in this wide territorial region. Further, our office uses various official languages, 5 in total, amongst which English and Spanish, which makes the threshold for US clients a bit lower. But they also use and accept the use of any EU language, any language spoken in the EU. The downside, maybe, or should we cover this later, is that, can I continue?
Yeah, no, absolutely. So I want to talk about that. There are downsides to having just an EU registration. So I'd love for you to address that.
So the downside of an EU trademark is that any party with an interest in these 27 EU member states has the possibility to attack or block your application from registration. So given that, you have lots of older trademark owners, this can give problems, of course. That's why we always advise our US clients to put it bluntly, to do their homework before they start seeking protection in the EU. And by doing their homework, I mean to have an availability search performed. This will allow them to identify possible hurdles they have to take, and even before a formal application is filed, to already make some minor or larger adjustments. For example, where a client has the plan to file for a word mark, but it notices that there are hurdles, it can already make the decision to go for a logo to circumvent these hurdles. You can also already advise your client on specifications or modifications of the goods and services to circumvent these hurdles, or if it's a real big pickle you come across, you can even decide rather to go for an EU protection, to go for national protections in the member states of the EU, which are the most relevant for you.
To your business.
Yeah, indeed.
Yeah. So I just want to explain really what that means. So what that means is when you apply for an EU registration and you get protection in all of these countries, if someone is challenging, so you don't, what's important for US attorneys to understand as they're counseling clients is in the US, we get registrations based on use. And in Europe, for instance, it's a first to file country. So there is no requirement for use initially. However, your registration can be canceled if there is no use in a certain number of years. And remind us how many years after the registration you must be using to be able to survive a petition for cancellation. Is it 3 or 5?
It's 5 years. So
okay.
As from the 5th birthday of the registration date of your trademark, you're obliged to be able to provide genuine use on the market. However, a big difference with a US trademark is that the office will not automatically request such proof of use.
Correct. So I'm just talking, right. So now I'm just, okay. So Slovenia is a member of the EU, correct?
Mm-hmm.
So I just want to use this as an example. So let's say that you help your client apply for an EU registration. And let's say it's 6 years later and someone from Slovenia challenges your EU registration and says you don't have use. And let's presume, just for this example, that your client doesn't have use in the EU. That Slovenian company can cancel your entire registration. And so that's really the pitfall. Yes, it's great bang for your buck. Yes, it's great value, but that's really where I think working with someone on the ground in Europe is valuable, as opposed to going through the Madrid protocol system,
Yeah.
And so that's really what I want to really impress upon our audience, that while it may be tempting just to extend through Madrid, what you're really getting when you work with an attorney on the ground is you're getting that expertise, you're doing that due diligence, you're doing that search, and someone like you can really help to advise them. And that's really the difference.
Indeed, indeed.
Yeah.
And maybe just building a bit more on the example of Slovenia, with regard to the use, if you're able, let's say that you do use your trademark and you use it in Germany, France, Italy, and Spain, but not in Slovenia, that is still not a problem. That still suffices as genuine use on the EU market. So even if somebody attacking you from a country where you do not have use, if you can prove use in other parts of the EU market, it's still enough. So
yes, that's true.
Because
yes,
that's a question we often get.
No, that's a really, really good point, because you're looking at the EU in total as one country.
Indeed.
Yeah. So I agree with that. And I think it's important to talk about it with clients as an entire strategy. While it seems like a great, like I said before, a good bang for your buck to just go for the entire EU, if their strategy is only to use in France, Germany, and maybe Spain, maybe then it really only makes sense to file for those national applications. But again, I think that's a decision to be made in concert with a qualified EU trademark attorney to really understand what the client's goals are and what the potential pitfalls are after looking at a search report.
Indeed. And maybe one additional point, which I haven't pointed yet, is that in regards to the descriptiveness and the distinctiveness of a trademark, is that the EU office will take into account any language spoken throughout the EU, which are quite a number of languages. And this is also something we notice that US clients do not always think of, is that they have a US brand, they wish to expand to the EU, and then suddenly they realize that the trademark, which is distinctive in the US, is not necessarily so because of all these many languages used and spoken throughout the EU. So that's something that clients need to be careful with as well. So we always try to advise our clients who have international ambitions already at the start of your project in the US, think about a possible expansion of your trademark protection somewhere in the future to the EU. So that's another level that needs to be taken in consideration when seeking protection on an EU level.
That's very interesting. I like that.
Yeah.
So what do you think, a lot of the attorneys in our course, and I think perhaps a lot of the attorneys listening to this, they have clients who are really small companies, startup companies. When do you really think it's the best time for those companies to think about perhaps filing in the EU?
Well, as you already indicated, as opposed to the US, we don't have the first to use rule, but the first to file rule. So as a thumb rule, I would say the sooner the better, but always make a good reflection on where you want to go and when you want to go there. We just talked about the use obligation after 5 years, and particularly for small clients, investing in trademark protection, well, is a substantial cost.
Yes.
It's better to invest cleverly rather than already going for a very broad protection territorially and then end up in a situation where you do not use your trademarks after 5 years. So it's always, as you already indicated, good to get in touch with a local specialist to see where a client wants to go and what their project business-wise is, and the rollout of their business will be in the EU as a whole, or maybe in some of the EU member states. So it's a bit difficult to give a clear answer to the question, but I think it really depends, and an assessment and a strategy must be determined on a case-by-case basis. So
yeah, I agree. I mean, I think I'm a big believer in strategy first. especially for clients who have limited resources or where, it's the difference between affording the trademark application. And certainly it is affordable, but then, there are, especially when you're considering international expansion, there are so many costs that go with that. Versus maybe investing in, a new e-commerce website or manufacturing or whatever it may be. And, I think it's important, and every business is different, I agree with you, but it's important to think about the fact that there are those cancellation procedures, which of course, to your point, are not automatic. And it's the same here in the US. But you have to consider that there could be a key competitor that is watching you, that is just waiting for that date to come. And that is a much more expensive proceeding to get involved in. So I think with that said, I'd love to talk about not only your opposition proceedings, because I know that those are very different than they are in the US. So in the US, opposition and cancellation proceedings are both done at the TTAB, and they certainly can be less expensive than a federal court proceeding. But I know that often European clients are quite surprised at how long they take, because we average about a 3.5-year time frame from beginning to end, if you take it all the way to the end. But most of those proceedings do settle at some point, and they can be quite costly. They can, cost anywhere in the $200,000 to $400,000 range. And I wonder if you could just speak briefly about the European system.
As far as oppositions
yes,
go,
please.
Once an opposition is filed, the parties are granted a cooling off period of 2 months, which allows them to find an amicable solution.
Okay.
There's always a possibility to jointly request a suspension of this cooling off period, so that it's extended with 24 months if you really need the time to find the solution. And our experience is that if you try to find an amicable solution once the opposition has started, that a suspension is relevant. But anyway, once the cooling off has ended, then the adversarial part of the procedure starts. And this means that each party, first the opponent and then the applicant, gets an opportunity to file arguments. The deadline, so the term to do so, is 2 months. Each party can request an extension of these 2 months with 2 additional months, and they don't really have to give a reason. So you just request for an extension, and it's always granted by the office. And then once the arguments are filed, the office will take a decision. And the reality is that it may take up to 6 months. So already it goes much faster.
Yes.
Well, let's say if all goes well without a long suspension and extensions, if all goes well, it takes you about a year and a half between the filing of the opposition and getting a decision from the EU office. And I have to admit that I'm quite shocked about the prices of the procedure on US before the US PTO, because in comparison, an opposition in the EU is really cheap. The fees you have to pay to the office are $350 US.
Wow.
This does not include, of course, the cost for representations, drafting arguments and negotiations. But I can say that if you go to drafting arguments, so no negotiations, it's about 5,000 euros.
Oh, wow.
And depending on how quick and how easy negotiations go, and how extensive an agreement, a coexistence agreement or a settlement agreement that needs to be drafted, it will also be somewhere about around 5,000 euros. So in comparison, let's say
I'm talking if it goes to trial, right? And everything is done on paper. But no, I know. I mean, I worked for a large European multinational corporation, and whenever we would get to the next stage and I would ask for a large sum of money, they would say, "Stacey, this is insane. This is not how we do it in Europe." I said, "I know, guys, but unfortunately, if we want to get to the next stage and hope to drive settlement, this is what we're going to need to do. And I know the systems are so different, but even I didn't know that. I didn't know that entire explanation about the process. So thank you so much for sharing that. I've managed a number of European oppositions with local counsel, but even I wasn't aware of that process. So I wish we were more efficient here. It's a wonderful strategic tool, oppositions and cancellation proceedings, and 97% of them settle at some point during the process. But it's those 2 or 3% that wreak havoc, and so many of them are filed, and that's just the problem. The board has such a backlog, I think, is the unfortunate part. I want to take a step back and talk about your application process in general. It's well known we have a backlog here, and we're having a little bit of a problem with our examination initially out of the gate for new applications. We've had such a surge, but can you describe a little bit what happens? So an application is filed, and then what happens, and how long typically does it take from filing a new application to registration at the EU IPO?
I think the EU IPO is known for having fairly quick registration.
Yes, I think so too.
So once you apply, the office will first check some requirements. It will look at the distinctiveness of the mark. It will look at the descriptions of goods and services. Possibly remarks are made, but if there aren't, it takes about 4 weeks before your trademark is ready for publication, which goes quite fast. So once your trademark is published for opposition periods, there's a 3-month opposition period, and if all goes well, it takes 4 months before your trademark is registered. The reality is that there's always a little backlog, so if all goes well, most of them are registered 6 months after the application date. So of course, when there's no remarks regarding the distinctiveness, no remarks regarding the description of goods and services, and no oppositions on file.
Okay. So if there is an office action regarding distinctiveness or something else, how long do you have to respond to that? Is it the same as here? Do you have 6 months?
You always get a deadline of 2 months.
2 months.
But,
oh, that's fast.
Yeah, that's fast. And the same goes for descriptions of goods and services. It's 2 months, so it goes quite fast. Yeah.
So even if there's an issue, it sounds like you could get a mark registered in a year.
Yeah.
Easily.
Yeah. Aside from oppositions,
of
if
course,
anything else happens, you still have it within a year, your trademark registration.
Yeah, but even if there's an issue during examination, so
yeah.
barring an opposition, which of course is different. Okay, wow, that's great. Okay. Anything else that we should know from the US perspective about trying to secure registrations in Europe?
I think maybe the most important thing is that there's a huge difference between the EU and continental Europe, and some of our US clients are not aware of this. Everybody knows in the meantime that the UK is no longer part of the EU, which is for many of our US clients an important market. But there are some other countries which are important, such as Switzerland, Norway, Turkey, not part of the EU, but we notice that many of our US clients still have an interest in these territories. So when you advise your clients, I would say to the attorneys, also think about, those countries which are not necessarily part of the EU. And maybe one final tip is to all companies with international ambitions is to really already start in the beginning of your project to consider if you want to go to the EU and do your due diligence, as you said, make your homework and check whether the trademark you fall in love with or is available and whether it will meet the distinctiveness requirements before you really start investing in it already in the US and then expanding it to the EU. And I think you already indicated it several times that it's really an added value to work with a local EU agent who knows the office, who knows the back doors of the office, and who knows the case law and knows how things will be interpreted and can help strategize on obtaining the best protection at the most affordable price in a quick manner, or at least as quick as possible. I think that's the most important things I wanted to share about.
I totally agree. I totally agree. Well, Katia, thank you so much for joining us today. I really, really appreciate it.
Thank you very much for having me. It was really fun. It's really cool that I had the opportunity to share some of my my experience and my knowledge with you.
Well, we appreciate it. Thank you so much.